Before we jump into copyright law, the introduction to copyright law, like I mentioned I was going to do after the last slide, I want to talk about the public domain before we go any further. What is the public domain? The public domain consists of intangible resources that are not protected by intellectual property rights. Every time you see IP, intellectual property rights, and are freely available for anyone to use. So which IP rights does the public domain, PD, public domain, apply to? All of them. All of them. The patent, the trade secret, trademark, right of publicity, and copyright. There are three main categories. What's in the public domain? There's three main categories. The first one is works that do not meet any of the intellectual property criteria. Facts. George Washington was the first president. The Gettysburg Address, the Constitution. George Washington chopped down the cherry tree. Facts. Titles. Titles are not in the public domain. You ever wonder why there's like several different titles of songs? Like one that pops into my head is we have Jump by Van Halen. We have Jump by a rap group, Criss Cross. There's Jump by the Pointer Sisters. Book titles, the same thing. But titles are not protected. They are in the public domain. Names are not protected. Ideas. I got this great idea for an invention. I got this great idea for a song. Ideas are not protected. They're in the public domain. So if you have a great idea for a song or an invention, you don't share it with anybody because they might think it's a great idea and develop it before you do. Symbols, numbers, mathematical equations, anything created by the government. Everything created by the government is in the public domain. Why? Why would you think everything that the government creates is in the public domain? Because we pay for it. Taxpayer dollars pay for it. And you see those photos from NASA all over science books and the website. It's in the public domain. They don't have to like it. They don't have to prove it. What if they say, I don't like the way you're using my photo? Too bad, so sad. It's in the public domain. You have no authority over it. So that's category number one. Category number two is works that have been given to the public domain. Creators just create and assign their works into the public domain for free access for everyone to use. Sometimes a creator will, maybe they're a photographer and they've worked their whole life as a photographer, and then they retire and they just want to submit their work into the public domain. Check out the Library of Congress, all of the works that are in there. Everything in the Library of Congress is public domain. I want to share with you the case involving Getty Images. Not sure if you are familiar with that. It's a website/business. A photographer filed a $1 billion suit against Getty Images for licensing her own image. This was just 3-4 years ago. Her name was Carol Hinesmith. She was a documentary photographer, and she worked her life as a photographer, and then she submitted all her works to the Library of Congress to be in the public domain. And she was posting a picture that she took of herself while she was on assignment somewhere and put it on her own personal website. Shortly after, she got a notice from Getty saying, oh, by the way, you owe us money for a licensing fee. She was like, what? It's my photo. Like, what are you talking about? My photo. So let's talk about Getty for a second. What do they do? They supply images. In the simplest sense, you can go in, type in what you're looking for, and they will provide you with samples of images that you can then pay for and download, and they have their little Getty Images watermark on them. So she sues them. She's like, you are unlawfully charging. So she goes to the website and checks out what they're doing and notices that a lot of the material on their website is in the public domain, which is free for anyone to use, but here they are charging for it. So she sues for unlawfully charging licensing fees in a falsely fraudulent claim of holding themselves out as the owner of those works. Okay, so she brings this big lawsuit. It was a big deal, at least on its face. It was a big deal. So Getty argues we're not holding ourselves out for being the owner of those works. We're supplying a service. What service do you think they're supplying, or at least they said they were supplying? The search engine, right? To find, we're helping you find what you want, so you don't have to go looking for it. You just type it in. That's what you're paying for. Our service to search and find what you need. And I'm going to take a little side note here on Getty. Previous to this case, a few years prior to this case, they got sued for doing the same thing with another photographer's photographs. His name was Daniel Moore, who sued Getty for, Getty was taking his pictures were on Twitter, and Getty would take the pictures from Twitter, put their little watermark on them, and then put them out there in their search engine, and they were getting paid and not the actual photographer. And that photographer won $1.2 million against Getty for doing a move like that. But in this case, this took a weird turn. The court dismissed the case. The woman lost. She lost the case. Why do you think, based on the facts that I told you? Because I told you in the facts what would get the court there. She put her works, after she retired as a photographer, she put her works in the public domain. And when you do that, you don't have any rights to them. You're not the owner. They're out there. And what did I tell you when we were talking about bringing lawsuits? A plaintiff who brings a lawsuit has to have a stake in the game. They have to, in this case, they would have to be the owner, the one who's actually damaged. And since she put her works in the public domain, she had no right to enforce or make the claim, so the judge dismissed it. But she did not have to pay Getty for the license fee. That was something that they worked out on the side. So the other category where we find public domain works, we already talked about works that automatically enter because of what they're not protected by any IP. We just talked about those that are assigned to the public domain by the creators. And then we have those that enter the public domain because of the expiration or the work's duration. For patents, we know that the term expires after 20 years. Trade secrets, if the secret is disclosed. Trademarks, if you fail to renew or fail to use, or there's an abandonment at some period. I failed to use abandonment also. My thinking of failed to use is you don't even start to use it. Failed to renew, you abandon it, you let it become generic. That's going to take it out of the protected. For the right of publicity, it's going to depend on the state. If it will pass, the right of publicity would pass to a heir upon the death of the celebrity. If it doesn't, it goes into the public domain. Otherwise, it's after that that term expires for the heirs. And in California, it's 70 years. I don't know what it is in Tennessee, which is the other state that recognizes it. And I'm not aware. There's more states that recognize it, but those are the two that stick out to me. You don't have to know the states. I'm just pointing them out as examples. So for copyrights, when the term expires. Now, we're going to talk about the duration of copyrights at length. I think it's going to be like a week discussion because they have gone through so much changes. Generally, it's when the term expires, okay? And if we go on that basis of when a term expires, this is our general outline of what we're looking at. We're dealing with works published in the United States before 1923. So anything actually from 1923 on now, is in the public domain. So if you see something that's dated prior to that, you might want to look into it. I never say to anybody, yeah, sure, that expired, because it's not, it's before 1923, because there's some caveats, and I'm going to give you some examples. All works published with a copyright notice from 1923 through 1963. All works published with a copyright notice from 1923 through 1963 without a copyright notice are in the public domain. That looks like there's a typo there. Between 1923 and 1963, if they didn't put a copyright notice on it, it expired. Just so I can clarify that. Because during that time period, the United States required that there be a copyright notice on things. And again, when we get to more of the discussion on the duration, you'll see all of the problems that have occurred with that issue right there. All works published without a copyright notice from 1923 through 1977. All works published without a copyright notice from 1978 through March 1st, 1989, and without subsequent registration within 5 years. This is not the time to discuss this breakdown. We will do that when we talk about duration. But the point here was the discussion of when things enter into the public domain, and as you can see, it's a little complicated when we're dealing with copyrights. It's not as clear cut as the patents or the trade secrets and such, but we'll cover it. I want to talk about Happy Birthday. There is a video. I'm going to update the video right here with this little lecture, but I think the content of the video and its discussion about the public domain is spot on, with the exception of it was prior to a lawsuit involving Happy Birthday. And the video would tell you that Happy Birthday is protected and not in the public domain, which was true up until 2015. And I want to tell you the story about it. And you ever notice, or maybe you work in the restaurant business, and the wait staff comes out and sings some sort of birthday celebration to a patron who might be there, but they don't actually sing Happy Birthday. They have some sort of spin-off to it. Do you ever notice when you're watching movies and it's somebody's birthday, they don't sing Happy Birthday? They, he's a jolly good fellow, or they do some other rendition, because they don't want to pay Warner Brothers, Warner Chappell Music, who had the licensing of Happy Birthday. And to give you a little background, they really dug their heels into this Happy Birthday, and here's why. They made $2 million a year just on this one song. Just on this one song, and licensing it out, they made $2 million. So there's this woman who is making a documentary. Her name's Jennifer Nelson. And she reached out to Warner Brothers, Warner Chappell, with regards to licensing Happy Birthday for her documentary. And she balked at what it was. And basically, they bill out at $1,500 a use in the song. So if you use it 3 times in a movie, that's 1,500 times 3. So she said no. And then she said, you know what? That should be in the public domain. It's been around forever, way before that 1923 date. So she did some research, and she led the charge and got some other musicians and filmmakers on board with her to bring this lawsuit against Warner Brothers. And their argument was, you don't own the lyrics. Maybe you own the musical composition. Either way, they brought in the actual, when it was created, who created it, the history. I mean, this is a woman who's making a documentary on the song. And Warner Brothers fought tooth and nail right up until the end, like they were on the eve of trial. When I say eve of trial, like within a week of having this case heard by a judge or a jury to determine whether or not Happy Birthday should be in the public domain. And Warner Brothers caved. They caved and they settled. They said, okay, Happy Birthday can go into the public domain. So Happy Birthday's in the public domain. Maybe we'll see it in movies more. And they paid back some money to others who they had licensed the song out over a specific period of time. So watching that little video is very interesting on how, if you don't take, what you should take away from it is how difficult it is to determine whether or not something is in the public domain, especially, I can't hit this home because, and we're going to do a whole week on music, in the music industry, using music. It's a little bit more, I'm afraid to say, clear cut if we're talking about a photograph. But when we're dealing with a song has many components. It has the musical composition, and it has the actual sound recording, and there's the lyrics, there's the music. There's a little bit more components, and the protections to them are different. But we'll talk about music and copyrights. So watch that video. Some works that are in the public domain. Mona Lisa is in the public domain. The Wizard of Oz book, or the book based on The Wizard of Oz. It's actually not called The Wizard of Oz, but it's the book where the movie has come from. That's in the public domain. Shakespeare is in the public domain. A number of Christmas, holiday Christmas songs, Hark the Herald Angels Sing, Deck the Halls, Silent Night, are all in the public domain. So you are free to record away. Let's see what's up next. So my next question is, if a work is in the public domain, is it free to use for whatever purpose you wish? And the answer is yes. You just have to keep your eyes peeled on this, right? You gotta make sure if you might run a snag into the right of publicity issue, so you want to work through the exceptions that exist there, okay? Public domain, why do we have it? Why do we have the public domain? Does it really serve any purpose? Do you think society has benefited from having it? Does it sustain further creativity and innovation? That's what the hope is, to build off of something that's already been done. But as you'll see, the durations times for copyrights has been extended several times. The patent hasn't been, duration for the patent hasn't been extended. Just we see this with creative works. You think that's fair? I think they should go into the public domain. When the duration was changed in the Sony Bono Act, the date escapes me, but it wasn't the last time. The last time it was changed was in 2018, and we'll talk about it. But the time before that, when it was changed, and Congress was changing it and passing laws, there was nobody there arguing for the public domain. There was a whole bunch of people there, like Disney, with lots of money, convincing Congress for the extension. Is that fair? Do you think we overprotect on these intellectual property rights? Do you think it's important to maintain a nice, extensive public domain database? I mean, it's certainly large, but it could be larger. What if we didn't have it at all? Would it matter? Would people miss it? Would we be able to reproduce so many Shakespeare spins off of on Shakespeare? There's no real answer to these questions. These, are just in theory, things to think about. But if Congress keeps extending the duration of copyright, which they've done several times, and now as I alluded to when we were talking about the executive orders, President Trump signed an executive order extending it. Corporations are lobbying the government. So that is the public domain. Now we're often running into copyright law. Oh, sorry, one more point. Creative Commons. What is Creative Commons? You must have come across the Creative Commons. What is it? Where does it, how does it differ from the public domain? Well, this is the actual creator retains their ownership rights. They just put it into a arena for people to use under certain conditions. They'll only license it for free only certain conditions. A lot of teachers' materials are in the Creative Commons, but there's a lot of artistical works in the Creative Commons that can be used for free. Sometimes they say just give us, acknowledgement for its use, but different than the person who puts their work into the public domain. So in the Creative Commons, it's like the public domain, except the owners retain their rights to the ownership, and they usually put limits or restrictions on it.